Ladies and gentlemen, welcome to the National Constitution Center, and thank you so much for coming. I am Jeffrey Rosen. I'm the president of this wonderful institution. The National Constitution Center, as some of you know, is the only institution in America chartered by Congress to disseminate information about the US Constitution on a non-partisan basis. And I can't think of any topic more important to commemorate and celebrate and learn about on a nonpartisan basis than the 50th anniversary of the Civil Rights Act, which we celebrate this year and in particular on July 2nd. We have several programs in connection with the anniversary of this act, which Clay Rosen in his superb new book accurately calls the most important piece of legislation in the 20th century. On May 14th, we will host a program with Bruce Ackerman of Yale Law School in conversation with the scholars Stephen Calabrese and Tomiko Brown-Nagin on the civil rights movement and how it amounted to a revolution in constitutional law. That's going to be an amazing pairing. Stephen Calabrese, the founder of the Conservative Federalist Society, Tomiko Brown-Nagin, and Bruce Ackerman, among the most prominent liberal scholars, all united on the importance of the act, and it's going to be a great discussion. We still have tickets on Wednesday to hear the curator and historian Sarah Lewis, who will discuss her debut book, The Rise, which features people like Frederick Douglass and Samuel Morse, and talks about what we can learn from failure throughout history. And she's on the cusp of becoming a household name, and I think it's going to be an amazing discussion. She just got a great review in the New York Times this weekend, so please do come on Wednesday if you're free. On April 21st, my friend Cass Sunstein of Harvard Law School comes to discuss his cleverly named book, Conspiracy Theories and Other Dangerous Ideas. And for the complete schedule of town hall programming, go to the website constitutioncenter.org, or just leave through this superb flyer. I'm just so proud of the incredible range of programs that we have, from Justice John Paul Stevens to David Boies and Ted Olson. It's going to be an amazing spring here at the National Constitution Center. You may have noticed some activity on the ground floor. Tomorrow, we are thrilled to open our new feature exhibit, Slavery at Jefferson's Monticello, a thought-provoking exhibit created by Monticello and the National Museum of African American History and Culture, and it will be open from April 9th through October 19th. And as you know, we'll be taking audience questions. Please jot them down on your note cards and silence your cell phones. Now let's begin. I'm so pleased to introduce my old friend, Clay Rosen. He is an editor at the New York Times op-ed page. We came to know each other at the New Republic magazine, where he was an assistant editor and I was the legal editor, and he was basically the best editor I had there. And I was just so proud and pleased when he went on to really great things. He was the founding managing editor of the noted quarterly Democracy, a journal of ideas, and has been just energized and presiding over a remarkably intellectually engaged op-ed page at the Times for several years. He's written for The Atlantic, Smithsonian, and The Washington Post. His previous book was A Nation on Fire, America in the Wake of the King Assassination, which was hailed as a crucial addition to civil rights history, and also American Whiskey, Bourbon, and Rye, a guide to the nation's favorite spirit. Why didn't you invite me to the book party for that?
Oh.
That must have been a
Sorry
lot
about
of fun.
that.
Sorry, please, let's, for the paperback.
For the paperback, absolutely.
Yeah, that'll be fine. Today, he discusses his latest book, The Bill of the Century, the epic battle for the Civil Rights Act, which is indeed a riveting and dramatic account of the most important act of legislation of the 20th century, and it'll be on sale in the museum shop after the show. Clay, congratulations on this superb book, which manages to take legislative history, which can be pretty dry, as well as in this case quite technical because of the opposition of the South and the maneuvers that they used to delay this bill at a time that 80% of the country supported it. But and yet you turn it into a sweeping, exciting, and morality tale. One of your big arguments is that President Johnson, although he deserves great credit for the act, perhaps was not its principal author, and that the contributions of many others have been overlooked. And you talk about senators like Dirksen Humphrey and Robert Kennedy. If you had to pick, it's tough, but you have to pick a single person who was most responsible for the act, who would it be?
Ah, wow. You know, it's first of all, thanks, Jeff, for having me, and it's always great to talk to you. That's a tough one. every day it's probably a different character. Today, my answer is Nick Katzenbach, who was the Deputy Attorney General at the time, later became Johnson's Attorney General, and was famously kind of the guy who quarterbacked the Voting Rights Act. But he also quarterbacked the Civil Rights Act. And by quarterback, I mean he really was the man who not only oversaw the writing of the bill and pushed for the bill. Pushed for the bill, first of all, helped convince President Kennedy in the late spring of 1963 that a bill was necessary, but then helped craft the bill in the Justice Department, and then just grounded himself in legislative politics and understood, I think on the level of a Johnsonian level, how bills get pushed through and how to get what you want out of a pretty disparate group of people. The House tended to vote in blocks, but the Senate, even back then, was very much, each legislator was an island. And how do you get all of them, it's herding cats, it's whatever your metaphor is, but how do you get them to back the version of the bill you want? And he understood that deeply. He was a law professor. He was not a politician, but he understood this. Somehow he figured it out, and was often in a position where he was negotiating with the other side, be it conservative Republicans or the liberal Democrats. I mean, it was really almost as if instead of there being a bill sponsor, it was Katzenbach, or he was playing the role of the bill sponsor. And he was there from the very beginning to the very end. And he had a whole team behind him. And of course, like you said, he was not nearly the only guy involved. But I would say, if you had to look at someone who does not deserve enough credit, he would be at the top of that list.
And you talked to him. He's in your acknowledgments as well.
Yes, yeah. He passed away in 2000, early last year. Or actually, no, I'm sorry, 2012. And but I did get to talk to him. No, maybe it was early last year. I'm sorry. But I did get to talk to him for the book, and he was very gracious. And he has a great memoir also. It's called "Some of It Was Fun," which gives you some idea about what kind of a man he was. He was very ironic and sort of very funny. But it's a memoir of his time in government service, and really helps bring home some of those stories.
He was the guy who typed out the oath that was then read over the telephone to the judge who swore in Lyndon Johnson after the Kennedy assassination.
Yeah, and he was the guy, if people have ever seen photographs of the stand in the schoolhouse door, where on June 11th, 1963, George Wallace literally stands in front of the administration building at the University of Alabama to block 2 African-American students from coming in. And a lot of this was theater, but it wasn't really organized beforehand. There was no real understanding of what Wallace was going to do. And federal troops or federal marshals and nationalized Alabama National Guard troops were there. And but it was Katzenbach who was going up against Wallace. And the photographs are striking, because Wallace is famously a bantamweight boxer, and he's 5'4" or so. And but Katzenbach was, I believe, 6'3". I mean, he's a hulking, a big guy, and he's there, sort of standing over him. And Katzenbach was not used to the Alabama heat. And in fact, there was some joking early in the morning about how he deserved hazard pay from the Justice Department because of the heat. So he's there sweating, and Wallace had made it so that he was standing in the sun. And Wallace, who's perfectly coiffed, I mean, he was always just this made for TV guy, perfect hair, everything. He's standing there, but it's one of those series of photographs that brings home everything about the civil rights movement. I mean, what's going from the federal government point of view? It's this federal government finally coming in and saying, you can no longer do this. And Wallace backed down, but Katzenbach was the guy pushing the door open.
Speaking of photographs, you mentioned the transformative effect on the debate of that famous photograph in Birmingham of the police dogs attacking the young children and the fire hoses as well. To what degree did that photograph and the media play a crucial role in the debate?
Yeah, it's fascinating. The media up until 1963 really hadn't paid that much attention to civil rights. Individual reporters had, of course, and a lot of them were very courageous in their reporting. But by and large, particularly the TV station, TV networks, a lot of the major newspapers were not that interested. They saw it as an issue that popped up every once in a while. It wasn't something that had a sustained urgency. But in 1963, you had this confluence of, first of all, events. This wasn't something they chose to cover. That they were really pushed by things like Birmingham, that was obviously of national significance. They were pushed to cover that. But also a generation of reporters and producers who were coming into their own and starting to realize, okay, this is something that has signal importance for American history, and we need to be there, not just covering it when news pops up, but actually getting engaged with the story. And so a number of these guys were down in Birmingham. They were photographing it, they were filming it, and those photographs, for the first time really, started showing up on the covers of newspapers, on the front pages, and on the covers of magazines, and first national papers and then international papers. And this had absolutely a transformative effect on the way that people in Iowa or North Dakota, I mean, overwhelmingly white states, where their understanding of civil rights was removed at best and ambivalent at best. They didn't really see it as something that they saw it as possibly two-sided. When they would see when violence would be reported, they would often reporters would kind of accept this idea that, well, the police, they were just enforcing law and order and the protesters were being violent. Suddenly they saw these photographs. I mean, a guard dog, a police dog attacking a child, fire hoses blowing children off their feet. There's no two sides to this. A photograph, talk about a photograph, a picture speaking 1,000 words, this did it. And it transformed the way that large swaths of the public understood civil rights. And of course, then you have the bill introduced, and you have an overwhelmingly positive reception for it. And I think the media played an integral role in making that happen.
Well, the poll numbers when the bill was passed were 80% in favor. What were the lows before the pictures? I mean, how much did things shift and how quickly?
Well, I mean, a lot of it was just ambivalence. I mean, and understand that there really wasn't, it wasn't just that there was so much that there was antipathy toward a civil rights bill. There was no conception that something like that was on the table. I mean, people were, so you'd have questions that sort of vaguely, but do you think African Americans deserve equal treatment? They wavered between 40% and 60%, but when the questions were always posed in very general ways, because no one really was conceiving of something as big as the Civil Rights Act coming into play. But those numbers, as soon as the bill came out and people saw these photos and the questions were being posed in very direct ways, you saw a jump in both the kind of general questions and very specific ones.
Many of those children came from churches, and you discussed the central role that religious leaders played in mobilizing support for the act, including preaching about it.
Yeah, and not only, now these were obviously, I mean, these were African-American protesters. They were coming from African-American churches and going back since the beginning of the movement, but highlighted by Dr. King's work around the Southern Christian Leadership Conference and his work through the Southern churches through the 50s. Obviously, you had that as a very strong element. But one of the things that's very striking about the Civil Rights Bill is, and the activism around it, is that you had a lot of congregations, constituencies that were all white in parts of the country where civil rights had never been discussed. Dubuque, Iowa, Maine, rural California. People coming together and not only agreeing that civil rights was a moral issue, but actually doing something about it. And preachers making it a part of their sermon. And it was organized largely through both the Catholic Church and the National Council of Churches, which you all actually, one of the great finds for this book, I did a lot of archival work, and one of the places where I found just some great, I think, unearthed material is at the Presbyterian Historical Society here in Philadelphia. And they have a wonderful archive. And they have an enormous archive of all of the work being done on race relations and racial equality in from the late 50s through the 70s. It really was a great moment for activism on the part of a segment of religious life in America that had never really been activist. Even through the 50s, the NCC, after the Emmett Till murder, their statement was something to the effect of, this is an issue for the courts. This is something the courts will decide. We don't know what really happened to Emmett Till. We'll let the Mississippi courts decide. Well, that was so dramatically different from what the NCC was saying by the early 60s. And not only were they saying things, they were getting the preachers, getting the congregations involved, getting them to write letters, getting them to make pilgrimages to Congress to go lobby their congressmen, and this was effective. There are testimonies from members of Congress, from their staffers, saying, "My God, we can't get anything done. These church groups come in," and I shouldn't also a lot of synagogues, a lot of Catholic churches. I mean, this was across the board. It was an ecumenical movement, and all of them coming in and sitting down with our congressmen or with staffers and saying, "Here's what we want. We want this, this, and this." They were very well briefed, very specific about, "We do not want you to compromise on this part of Title II," right? And everyone was taken aback, but it was very well organized and was very effective.
At times, the passion of the activists was too much for the administration. You tell the riveting story where the young activist said that he wouldn't serve his country and yelled at Robert Kennedy. And Kennedy was at first appalled by the bad manners, but then thought hard about it and said, "Maybe I can actually empathize with
it's one of the great stories, rightly emphasized by all of the biographers of Kennedy. Schlesinger and Evan Thomas in his biography. There's this transformative moment because when you think about Robert Kennedy, there were really two Kennedys in our historical understanding. There's the Kennedy of the 50s, the buddy of Roy Cohn, and the guy who's going after labor and really just a tough as nails, not a particularly liberal guy, certainly not an empathetic person, and not someone that anyone liked. And then there's the Kennedy of the late 60s, who couldn't be more different. And at one of the hinge points is this meeting where he goes to New York. James Baldwin, or he had reached out to James Baldwin to talk to him about, what is this? What's going on with race in the South? He didn't understand, really, but he wanted to. He was a very inquisitive guy. So Baldwin set up this meeting with a number of activists, not only young activists, but also some famous women. Sidney Poitier was there, and Harry Belafonte, and Lorraine Hansberry, and of course Baldwin was there, Lena Horne. And they just ripped into him, and including one who said, "I will not serve my flag. I will not serve my country. I refuse to support this country when it discriminates against me on the basis of my skin. This is unacceptable." And Kennedy was taken aback. "How can you say that to the Attorney General? How can you say that about our country? What are you talking? How can you be so just aggressively offensive?" And yet, in the days after, he started to change and started to think about, there's something to what these guys are saying. And it's one of the reasons, I think, why the bill came out when it did. Because Bobby Kennedy, it was almost a Saul on the road to Damascus moment. One moment he's Saul, well, the next moment he's Paul. And he's suddenly just completely behind this idea. And then he goes to his brother and he says, "Look, something has to happen." And this is what, in May of '63, was so important. This happened in the beginning of May. By the end of May, we had a bill written, and then a few weeks later it was introduced.
JFK famously ambivalent, keeping his options open and really just going with the tide.
Yeah, sure. No, he had run on race or on civil rights in 1960. Had really, pretty inarguably won on the black vote. It was a very close vote with Richard Nixon, and he had won the black vote. But then he pretty much ignored it. Some token things here and there to sort of bide the time. Kennedy was, it wasn't just a political thing. Kennedy was a guy who had really imbibed this idea that the South would come around, and he was an incrementalist. He had, if you read his treatment of LQC Lamar in Profiles in Courage, this is a Southerner. He was a Confederate who later became a Supreme Court justice, and he gets a very good treatment from Kennedy, who then goes into just tear apart guys like Thaddeus Stevens, who were very, were ardent abolitionists and real, the architects of not just Reconstruction, but of the Reconstruction amendments. And so that was Kennedy's point of view, was things will come around, and of course they didn't. And it took events like Birmingham and like Bobby Kennedy's transition for John Kennedy to finally overcome both this intellectual background, this intellectual opposition to civil rights legislation, and this pragmatic concern about angering the South.
You mentioned Thaddeus Stevens. Our friends may remember him from the Lincoln movie, Tommy Lee Jones.
Yeah.
But this is the hero of Reconstruction, more responsible than anyone else for both pushing through the 14th Amendment and also the Civil Rights Act of 1875, which included a public accommodations provision, would have done much of what the Civil Rights Act of 64 did, except that the Supreme Court struck it down. It said that Congress did not have the constitutional authority to pass it. So tell us, first of all, about how it was that this the Reconstruction achievement wasn't more embraced by liberals like Kennedy when the whole thing started off, and also why was it that the architects of the bill were here at the National Constitution Center, and I want to talk about the constitutional aspects associated with this bill. Why didn't the authors of the 64 Civil Rights Act, rooted in the 14th Amendment, which Stevens and others passed precisely to allow Congress to enforce equality, and instead they chose Congress's power to regulate interstate commerce? Why was that?
Well, it's a good question. There were really sort of two sides to it. There was a political side. Republicans rightly looked to the Reconstruction amendments and said, those are Republican amendments. The Republican administration, the Lincoln administration, and then later enforced by Grant, those were Republicans did that, and that's our legacy. They were the party of Lincoln, and so they always looked at the 14th Amendment as something that they saw as the key to promoting African American rights, equal protection in the face of law. Now, Democrats looked to the Commerce Clause, which had been so instrumental in expanding the power of the federal government during the New Deal. And it was just there, they had used it. A lot of the lawyers who were working on this bill in the Justice Department, and as well as a number of legislators by that time who had been around since the 30s, it was just a given that that was the tool to use. And it was, the federal government can basically tell people in the states to do something if they can link it to commerce. So that was kind of the political side. There was also an intellectual side. And by the 60s, there was definitely a feeling that the Supreme Court had made an error in overturning the civil rights laws. That the civil rights laws, at the time had been ruled unconstitutional because they said, the 14th Amendment really only applies to the government. And so you can't use that to tell private individuals what to do. And over the subsequent decades, that had been essentially understood to be a poor decision. And Justice Harlan in his dissent had rightly outlined the proper criticisms that more or less had become accepted. But at the same time, you had a number of these guys who were on the Democratic side in the administration and in Congress were nevertheless, they had an intellectual sort of straitjacket. I mean, this was still what they still believed, that when it came to the 14th Amendment, that it was shaky, that it was, if you had the choice between the two, that's not the one to go with, that you're going to have a lot of problems, even if it's fundamentally correct. Now, I think ultimately this was a political, well, first of all, it's an intellectual error. I mean, they should have seen the strength of that argument and the strength of kind of the present moment, the Warren Court being very friendly to expanding state power. This was probably not going to be an issue. But I think they also made a political error in that everybody knew they needed Republican support behind the bill. I mean, this was a Democratic bill going into an election year. It was going to be very hard to get Republicans to support the bill, and yet you needed them to counter this dramatic, very strong opposition from Southern Democrats. So why not use the 14th Amendment? Why not use that as, if not the justification, one of two equal justifications? You would win over a lot of support. And the fact that they didn't actually caused a lot of problems in Congress.
Might it have shored up Congress's ability to enforce anti-discrimination laws today?
Absolutely.
I mean, it's an incredible story that the Harlan dissent that you mentioned is one of the most dramatic in American legal history. Justice Harlan has writer's block. He doesn't know what to say to object to the fact the court is overturning the 75 Civil Rights Act. Forgive me for this, I just can't resist sharing it.
Please.
And his wife suddenly has an inspiration, and she sees in the Supreme Court the inkwell that Roger Taney used to write the Dred Scott decision. Wow is right. So she puts it on Harlan's desk, and he comes back from church, and he sees Taney's inkwell, and he's seized by divine inspiration, and he writes out the whole thing in an afternoon, effacing the blot of Taney's error. but it's a dissent at a time when his colleagues have literally struck down the very act that would have vindicated his position, and it took another 100 years. So if these New Deal lawyers had not been so squeamish, they could have embraced the Harlan position, and the Supreme Court today might not be narrowing Congress's power to enforce equality as it's doing.
Absolutely, because as you know, I mean, this was the height of, you know, in a lot of ways, the height of you know, the post-New Deal liberal era, and with the Warren Court being what it was easy to accept the idea that the Commerce Clause would always have the weight that it did, and that it would always be read as this very expansive tool. And of course, that's not what happened. Over time, the court became more conservative, and of course began to eat away at legislation that had been rooted so firmly in constitutional and in Commerce Clause powers.
Tell us about some of the other constitutional objections to the Civil Rights Act. Robert Bork wrote a famous article questioning its constitutionality, and there was concern about property rights.
Yeah, I mean, the central argument against both Title II, which outlawed public discrimination in places of business, you know, essentially striking down Jim Crow, and Title VII, which regulated employment discrimination and banned employment discrimination. Both of those were opposed on constitutional grounds as infringements on property rights, and that people were not, or that the Congress, federal government, did not have the power to force people to associate. Essentially, that was Bork's argument: is you can't force somebody to you know, be nice to someone else, essentially, or to associate with them. And this was a strong argument. Now, and Bork was not a Southern racist. This was a strong argument that a lot of people outside of the South and the Southern Democrats took to heart. They obviously took it to heart, and I think some of them honestly believed that. It's kind of inextricable from their deeply held segregationist views. I think those were part and parcel with their constitutional views. But guys like Barry Goldwater opposed this on the same grounds. And you know, it's funny the way that you see the same arguments popping up today. And I think, as we were talking about before, one of the things that we've, I don't know, maybe it's just the way Americans don't remember debates that we used to have. I mean, essentially the legacy of that discussion, because this debate was had very extensively in Congress and in the press, in the public, and it was decided in favor of the Civil Rights Act. Nevertheless, we have these debates now where Rand Paul gets up and says, I wouldn't have supported the Civil Rights Act. I wouldn't have supported Title II because it's an infringement on property rights. And you see millions of Americans say, oh my God, that's what the Civil Rights Act says? Well, that's not constitutional. And as if we had never had this discussion, as if Congress had never decided, okay, that is constitutional, and the Supreme Court a few months later saying, yes, that is constitutional. Nevertheless, we have this conversation again, and this isn't the only time this has happened. I think you can point to a number of places where we have the same discussion over and over. But it's striking that on a piece of legislation and on a question where this country made a dramatic leap forward and decided certain questions pretty definitively, we are now having those same debates. And I think it's, you know, it's cause for concern.
As we were discussing, the Supreme Court is about to decide whether to hear a really important case involving whether a wedding photographer in New Mexico can refuse to photograph a gay wedding because her associational and expressive rights are being infringed. And she has cited the Robert Bork article opposing the Civil Rights Act. We had a great podcast, and I'm going to put in a plug for our phenomenal We the People podcast just the other day, where Richard Epstein, the leading libertarian in the country, debated Jeff Stone on this Hobby Lobby case, and he thought that Bork really went too far. He didn't have to say that it was a principle of unsurpassed ugliness to compel association, but he acknowledged too that this debate was had then and to some degree settled.
Yeah, no, it's quite striking, and you know, unfortunately, I think it's something that you know, is particularly appealing to young Americans who did not live through that period, who don't feel quite this. I mean, they understand that racism is bad, and they understand, but they also believe that we don't have these problems anymore because of what the Civil Rights Act did and the Voting Rights Act did. And it's one of the unfortunate and inescapable ironies of progress is that you take a step forward and you forget where you came from and you forget how you got there. And it's very convenient for a lot of political forces to kind of try to erase that past. So, you know, I grew up in the South, and I grew up in Nashville, and it's not that I was not taught anything about civil rights. It was not part of my education, and yet I lived in a place where, before the Civil War, was a hotbed of slave trading. Was obviously in the slave South, but had been a center point of the civil rights movement, and yet was not part of my education. And so I can understand, although I don't obviously feel comfortable with it, but I understand how young people today can turn around and say, well, why is it possible that the Civil Rights Act can compel people, or that the federal government can compel people to, serve a gay couple? Why is that fair?
Or buy health insurance or broccoli.
Or,
it's the same,
exactly.
it's the same argument as the
absolutely,
Affordable Care Act.
absolutely, yeah.
Very much so.
Yeah.
Much of the narrative power of this great book is just the story of how Nick Katzenbach and the Kennedy and then the Johnson administrations overcame the resistance of these extremely entrenched, well-organized Southern minority senators and passed the bill. You've got to read the book to get the full power of it, but can you give us the two-paragraph version of what the main touch points were and how they did manage to overcome the filibuster and cloture requirements and get the thing passed?
Yeah, I mean, one of the things that's interesting about the '64 Act, unlike, because there were two previous civil rights bills, and there was a '57 Act, or two previous acts that actually passed Congress. The '57 Act and the '60 Act, and both of them had started off pretty strong and then been whittled down. And there was no filibuster really over the '57 Act. There was one over the '60 Act. And in both cases, the Southerners essentially stepped down once they got what they wanted. So they negotiated. What was different about the '64 Act was they made from the very beginning, they made it very clear, we are not going to negotiate. We are going to fight this to the end. If you read their rhetoric from the time, it's apocalyptic. And they say, we are going to fight this until the last one of us is standing. And this is sort of military, it is one of the reasons I call it the epic battle. It really is, from their point of view, a battle. And so they presented not a force to be reckoned with, but an obstacle to be overcome. And a lot of the excitement, and I think of the interesting part of the story, is how the different factions that were around the bill came together to create a large enough block to vote for cloture. And cloture is, when the Senate decides to bring debate to an end. And then, because everyone knew there was enough support to vote for the bill, but whether there were 2/3, and at the time you needed 67 senators to agree to cloture, it was never clear whether they would have enough of those votes. And a lot of those votes, they had to come from Midwestern senators, conservatives, people who had traditionally aligned with the South, not because they were particularly racist, but because they just didn't see race as an issue. So they were willing to say, yeah, we'll vote against civil rights here, and you'll vote for us over here, and we'll just trade like that. So it was a matter of convincing them to come over. I know this is a lot more than 2 paragraphs.
No, it's fine. Let's have the 10-paragraph version.
Yeah, okay.
It's worth it.
And the key to that, and the thing that they knew, that the planners and the organizers behind the bill, both in and outside Congress, knew from the very beginning, was they would have to win over Everett Dirksen, who was the minority leader of the Senate, was a conservative, but establishment conservative senator from Illinois. Also someone who had, it certainly was more or less pro-civil rights in a general sense, but didn't really ever have any sort of sense of urgency about it, and had some serious concerns, very much rooted in opposition to Title II and Title VII. So that he expressed early on. So a lot of the excitement and the tension of the filibuster sort of politicking is, how do you get Dirksen to come over? Because if you can get Dirksen, then you can get maybe not every Republican senator, but you can get a lot of them. And you can get a lot of these Midwesterners, because he represented and sort of spoke for them. Not everybody liked him. He had a lot of enemies within the Republican caucus, and there were people at the very end who tried to scuttle the whole thing simply because they didn't like Dirksen, and they were willing to let the whole bill fall because they were trying to make him look bad. So there's a whole sort of right up to the very end tension. Are we going to get enough votes? And at the very end, Hubert Humphrey, who was kind of the field manager in the Senate for the bill, he was working the phones until late the night before the filibuster vote, and the next morning working the phones, just trying to get 1 or 2 more guys to come over, and really just begging Dirksen, please promise me you can get these votes. And in the end, of course, they won by 4 votes, and it was It was a comfortable but still very close decision.
Would it have gotten through today, in today's polarized Congress?
The easy answer is no. I think it's hard to say because it's one of those time travel questions, right? I mean, part of where we are today is because of what the Civil Rights Act did. I mean, it helped rewrite congressional politics and helped rewrite the alignment of the parties. The South changed dramatically in part because, the Southern politics changed in part because of that. So that's tough to say, but still, nevertheless, look, I think we would have probably had something. I think that it would have been much more compromised. But one of the hallmarks of politics today that's different from back then is that you had party bosses back then and party leaders who could really basically tell the rank and file congressmen and senators, okay, you have to do things this way. More the House than the Senate. But they could still more or less say, this is what the leadership wants, you have to do it. Today, that doesn't exist at all. And you have, not only do you have the lack of, or sort of a disappearance of an establishment, but a real disappearance of these sort of party bosses that ran the establishment. And in their place, you have interest groups, and you have powerful donors, and you have movement politics that, particularly on the right, but on the left as well, who always try to drive every piece of legislation in one way or the other, even if it doesn't relate directly to something they care about. They see it within their own kind of narrow worldview as how it intersects with their particular interests. So I think that, yeah, you probably would have had something, but it would have been much less strident, much less direct. One of the beauties of the Civil Rights Act is that while it's a very big bill and it covers a lot of ground, it's also very clear in what it covers, what it doesn't cover, how it drives enforcement, what the principles are behind it. I don't think you would have had anything like that today.
A question about sex. Howard Smith famously inserted the word sex into the bill. Some people thought he was joking. You suggest maybe he wasn't. What was the story?
Well, I think it's one of these. He's a very complex figure. He was the head of the Rules Committee, Southern Democrat, very powerful man, very ardent segregationist, really tried to block the bill in the Rules Committee. One of the things Johnson did do was help push it out of the Rules Committee, and he very clever in that. But when the bill got to the House floor, Howard Smith was still trying to block the bill any way he could. And he said, well, what if we have this Title VII, and Title VII says you can't discriminate against people in the workplace on the basis of race and ethnicity or national origin. There's some other sort of tweaks on that basic concept. He says, well, we are not covering women here. Why don't we cover women? And of course, that had been something that had not been included in the bill for partly because it was a very radical idea. Why would we do that? This is a boys' club. We don't really cover women. But also because even people who did support women's rights had the feeling that this bill is already going to be a really tough sell to the rest of Congress and to the public. Let's not weigh it down with something else. So Smith was definitely trying to throw a wrench in the system. But Smith was also a long-time supporter of women's rights. And it's hard to conceive of this today because we see these two as very related, sort of parallel, minority rights, women's rights, being very much in sync. But there were ways, particularly at the time, that people were adamantly segregationist, but believed that women had certain rights. Of course, they were thinking white women primarily. But Smith was one of those people, and he had always supported the Equal Rights Amendment when it came up. He had supported bills to protect women's rights in the workplace. And so, I think it was probably a mix of both. That he was using an issue that he felt strongly about to try to scuttle the bill, or at least cause some problems for it.
That fissure is historically deep, and of course in the years leading up to the 19th Amendment, which guaranteed women's equality, the women's rights movements decided to abandon African Americans and basically bless Jim Crow on the ground that the women's hour has come. It was our turn.
Yeah, and in fact there's a weird sort of calculus certainly in Smith's thinking. He saw, okay, we're going to have this civil rights legislation, and it's going to protect black people. So that means black men and black women. Now, white men are already in the catbird seat, so what does that leave out? Well, that leaves out white women. So I'm a good chivalrous Southern man. I'm going to protect white women. And that was his logic in the decades leading up to the bill, and that was certainly his logic in inserting this.
Amazing, and now it's the anchor of contemporary gender equality.
it's really, but actually one of the problems for that element of the legislation was the fact that people thought this was a joke. So when the Equal Employment Opportunity Commission, which enforced Title VII, got underway, it got very deep into racial discrimination issues. But whenever women would bring up sex discrimination, the early commissioners, or not all of them, but some of them, the majority, would say, well, we don't really take that seriously. You don't believe that was really part of the law, right? That was Smith's joke. And but that was, in a way, ironically, a good thing, because that made women lawyers really get involved. And the National Organization of Women was founded in large part to help push the EEOC to take sex discrimination seriously. And so over the course of the 60s, you see this growing, basically, women's rights bar around employment discrimination. And in some ways, was the catalyst for that very strong legal approach to women's rights that carried the women's movement, or a large part of it, through the 70s and 80s.
How successful was the act? Tell us about its reception and subsequent enforcement and interpretation by the courts. I mean, how successful was it?
Oh, it was incredibly successful. I mean, strikingly. I mean, in the days after, Title II was the thing that everyone was really focused on because it had an immediate impact. Title VII was more or less kind of phased in, not entirely, but but Title II was this thing where the president signs the bill tonight, and tomorrow stores cannot discriminate against blacks. So this is going to be tested. And there was a lot of tension. There was a lot of fear that things would, that there would be violence, or there would be, on the part, of course, some people said it's going to be violence on the part of blacks. And others said, well, no, it's going to be white opposition, and they're going to beat people who try to integrate these stores. That did happen. There were cases across the South of violence against testers, largely what these the early integrationists were considered. But what's striking is how little there was. And by and large, the bill was, Title II was accepted. And some stores closed down. Lester Maddox famously closed down and then used that exposure to become the governor of Georgia. A number of cities closed their pools and public facilities that the bill would have opened. But by and large, the South more or less accepted the mandate of the federal government. And it's interesting. I mean, it's interesting to contrast it with Brown. Now, obviously, the Brown decision in '54, this is 10 years later, 10 years of change. But the Brown decision was violently opposed by the South. And the white citizens councils rose up through the 50s in organized opposition to Brown. And a large part of the argument against it was, this is the Supreme Court speaking. This is nine men in a room in Washington. They don't speak for the people. They don't speak for the federal government. Who are they to tell us what to do? Contrast that with what happened over the Civil Rights Act. This was a bill that came out of Congress, was overwhelmingly, in the end, supported by the House and strongly supported by the Senate. It was debated. It took a year to pass through from Kennedy's origination to Johnson's signing. It was covered in the media. It was debated everywhere. There is no question that this bill has the mandate of the elected government of the United States. It was then, very soon after, taken to the Supreme Court, and it was affirmed very clearly by the Supreme Court. So there's no question that this is the law of the land. And for a lot of people, that was a very compelling message. Even the majority of whites in the South did not like this by any means, the vast majority, but this was the law. And to their credit, guys like Richard Russell and William Fulbright and these Southern senators who had led the filibuster went on radio, went on TV, and wrote statements that said, I don't like this bill, but the bill is now law. Support it. We must, if the Supreme Court overturns it, great. But until then, we have to follow the law, and we have to do it peacefully, and we have to do it as American citizens. And that was incredibly important, and it really made a difference. Now, if I can go on
Please.
just a little bit more, Title VII obviously, rewrote the workplace in America. And what's important about Title VII was actually what was considered a weakness at the time. The way that it was originally constructed, it gave the EEOC enforcement powers. The EEOC could decide that a company had discriminated, and it could go in and force them, as if they were a court, go in and force them to right their ways. It was eventually watered down so that it had to be taken to, if the EEOC decided that there was a case, it then had to be litigated. And the federal government or the Justice Department could intervene on the side of the plaintiff, but they didn't have to. And so that meant that maybe the plaintiff was kind of on his or her own, except that there was a provision that they would cover attorney's fees. The federal government would cover the attorney's fees. So that gave an enormous incentive to lawyers to start to specialize in anti-discrimination law, to the point where an enormous anti-discrimination bar, or EEOC bar, or whatever you want to call it, emerged, and it was much more powerful, much more effective than had the EEOC been doing it by itself, because it had been overwhelmed. I mean, you couldn't have a staff large enough to undertake all of the litigation or all of the cases necessary. So that was very important, and of course it changed the workplace for women and for minorities. The enforcement on schools was also absolutely vital. One of the things that's often forgotten about Brown is that Brown was a Supreme Court decision, but it didn't have an enforcement mechanism. Brown 2, the decision that came a year later that was supposedly enforced it, as everyone knows, said with all deliberate speed, states should integrate their schools. Well, what does that mean? And it didn't really explain what that meant. So states just dragged their feet, and there was really no integration at all of schools across the South in the subsequent decade. Actually a number of titles in the Civil Rights Act dealt with that. Gave the Attorney General power to intervene in lawsuits, right? Because obviously, if you were after the Supreme Court had made their decision, and you were a black family in Tuscaloosa, you could sue and you could say, my child deserves to go to this school. The Supreme Court said so, but you were on your own. And what would you get out of it? Your kid would get to go to school, and nothing much would change. So suddenly, the Attorney General can intervene. Well, that changes everything. It also created a lot of financial incentives for schools to integrate. It gave them money. There was a lot of, particularly in the outer South, where discrimination was maybe a little, or segregation was a little more porous. A lot of school districts nevertheless said, we can't integrate. We don't have the money to do it. We don't know how to do it. We're just not ready. Just come back in 5 years. So Civil Rights Act said, oh, we'll help you with that. We'll give you the money. We'll give you the training. The last thing that was really important, and this was important across the board, was Title VI, which said that the federal government gives money to the states, gives money to localities for a variety of programs. That money cannot be used in a discriminatory fashion. Now, at the time, the bulk of that money was agriculture subsidies and things like that. So, that was important. It was some highway building and things like that. And so it was important, but it wasn't, an enormous effort or enormous amount of money. The subsequent couple of years, the Johnson administration created and passed a raft of laws. In this case, the Elementary and Secondary Education Act, first and foremost, which gave billions of dollars to the states in education aid. Well, that all fell under Title VI. So suddenly, you had billions of dollars available to the states, but only if they integrated their schools. Well, you had school districts falling over themselves to integrate in the years following. And of course, now we're seeing that this is being eroded as well, or has been significantly eroded. But through the 70s and 80s, the South was at the forefront of integrating school districts.
That is one of the most striking things about this book, that it wasn't until the Health and Human Services guidelines that allowed funding to be withdrawn from schools that didn't comply, that schools actually became integrated more than a decade after Brown.
Right.
We should have another podcast debate about whether that unfunded mandate might be constitutionally questionable under the part of the Affordable Care Act decision that questioned the ability of the federal government to require states to accept Medicaid as a condition of funding. So all that is back up again. Lots of great questions from the audience, as usual. You guys are great and always put your finger on the right issues, so here are some of them. Everything from public education to immigration has been proclaimed recently as the civil rights issue of our day. Based on your reporting and insights, you've documented which contemporary topic comes closest based on a similar cast of passionate characters and moral imperative. Explain the comparison.
It's tough. I mean, in some ways, the civil rights movement was the civil rights issue is so unique to the situation that it's hard to draw a parallel. But I would say the gay rights movement is probably the one that comes closest. Again, it's not quite a parallel. It doesn't have quite the history that the civil rights movement did. The civil rights movement in the 1960s could say, we've been fighting, we've been fighting the legacy of the Civil War, we've been fighting the legacy of slavery since, for 100 years. And of course, the story goes back beyond that. With gay rights, it's not that, obviously, discrimination is nothing new, but the idea of equality for gays and lesbians is a relatively new idea. That said, I think that a lot of certainly the movement politics is very comparable. And also the legal issues involved and the constitutional questions, I think, come closest to what was driving the civil rights movement. And of course, the moral passion behind it is probably the closest comparison.
To complete the analogy, would the gay rights movement have to culminate in a totemic statute like the Civil Rights Act of '64, or would a court decision be enough?
I think one of the things that's striking about the gay rights movement, and I think it benefits from the fact that the civil rights movement happened when it did, is that the country is moving much more rapidly toward acceptance, where you can have court decisions that are more broadly accepted than they would have been on civil rights. It's telling that Brown was not accepted, that that there were a number of decisions that were looked upon as favoring the Warren Court favoring a minority, and that was somehow unacceptable or illegitimate. And today, you just don't have that same vehemence.
Fascinating. To what extent do you estimate that international opinion of the U.S. and the U.S. image abroad influenced the passage of the '64 Act?
Well, it definitely influenced Kennedy. One of the things that Kennedy was most concerned about, separate from just in general, is the image of the U.S. abroad. He was a Cold Warrior, and he really did believe in the soft power of the United States. He really did believe that the United States was a force for good and had a role to play as a moral arbiter in the world. I mean, it was his reason for doing Peace Corps, and the reason for the reason for him getting involved in Vietnam. I mean, he had this vision, and so when pictures of dogs attacking children in Birmingham started appearing on the cover of Soviet newspapers, John F. Kennedy took notice, and of course he wasn't alone. U.S. newspapers reported this is what the they always did. There was probably folks here, some of you remember, there would be occasional reports about, well, this is what the Soviet Union thinks about us. And there were articles about, here's what the Soviet Union thinks about discrimination. And of course, the Soviets were very aggressive in using Jim Crow and using racism in the United States as an argument against American power and against the legitimacy of the American model. And so, yeah, absolutely. I think first and foremost with Kennedy, but really did help drive public opinion.
A great bipartisan question. Republican senators played a crucial role, including Hugh Scott from Pennsylvania.
Yeah.
Please discuss their role in the passage of the act versus the Southern Democrats who opposed it.
Yeah, well, the Republicans were split between, you had a number, a significant but minority of Republicans who were by any measure liberal Republicans. Jake Javits and Hugh Scott and Tommy Kuechel from California were probably more to the left than most Democrats today. And they were always very aggressively pro-civil rights and very admirable in that respect. And yet, because of that, they were actually important in the crafting of the bill and in the sort of promotion of the bill as a bipartisan action. But they were not the key negotiators because they didn't have, of course they were going to vote for the bill. It was really the conservatives who were critical. There really weren't any conservatives who backed the Southern Democrats on ideology. There wasn't. John Tower actually was the only one. John Tower caucused. John Tower had been elected to replace Johnson, so he was the first Southern Republican senator in a long time, and he caucused with the South on civil rights. A lot of the new Southern Republicans who were coming up were all either in line with Southern Democrats on race or to the right of a lot of Southern Democrats on race. So John Tower, but he was really the only one. The rest were, aside from Goldwater and a couple of other Goldwater followers, the rest were kind of ambivalent on civil rights, and at the beginning. And it took grassroots efforts, and it took the persuasive powers of Everett Dirksen to bring them around. But it is very significant that a number of people who opposed the federal government on a long list of programs going back to the New Deal, nevertheless voted for a piece of legislation that gave the federal government so much power in terms of enforcing African American civil rights. It is anyone today who says that is a hallmark of the Republican Party, they are absolutely correct. They should be very proud of that legacy.
Last questions, and we'll take them together. First, would John Kennedy have been able to get the Civil Rights Act passed? And second, does President Johnson's legacy need to be re-examined?
I think, so let's see. I think that President Kennedy, yes, I think it would have passed. I think, look, I know no better than anyone else because it's an impossible question to answer. But I think, look, he probably would have taken a compromise on the bill. The political calculus was such that he just needed something. Something was going to pass. He needed something. That's what he wanted in order for him to shore up the black vote. A lot of it depends on sort of what happened in the streets. If things died down, then he probably would have felt a little less of that moral urgency and would have been willing to compromise. Johnson, part of the reason why Johnson gets the credit he does is because Kennedy exited the scene on a high note. He was very adamantly in support of the bill, and it was very necessary and obvious for Johnson to step in and say, we have to carry this forward. Johnson's legacy, I think it needs to be re-examined in the sense that the reasons why he's a hero of the Civil Rights Act are often misunderstood. He's often seen incorrectly as the author of the bill. That's just not the case. He inherited it. He wisely did not involve himself in a lot of the backroom negotiations. He let Nick Katzenbach do that. He let Hubert Humphrey, he let the guys who were already doing that do what they were doing. These were good guys. These were people who knew what they were doing, were very impassioned about it, already had networks together. Johnson did not need to get involved. I do think in the back of his head he was a little concerned about getting too close to the issue in case it failed, in which case he didn't want to be. In fact, he often said, anything that I sign off on, I want Bobby Kennedy to sign off on as well, so that I can blame Bobby Kennedy. It also just goes to his antipathy toward the Attorney General, but also gave him a scapegoat. But the thing that Johnson deserves credit for, and I think had he not done this, the bill would have been very different if it had survived at all, was to get up from the very beginning. I mean, on November 27th, his first speech after Kennedy's, 5 days after the assassination, he gets up in front of a joint session of Congress. This is live on all the televisions across the country, and he gives this speech that you can go listen to it on YouTube. It's one of the most impressive speeches. It doesn't sound like what we think, or what I think Johnson sounded like. He sounds like a Southern preacher. He not in the Martin Luther King version, but in kind of an old white Baptist preacher. I mean, really just the cadence. I mean, but it is such a good speech, and it's all about civil rights, and it's all about why we as a country need to follow the legacy of John F. Kennedy, and we need to take his martyrdom, essentially. He doesn't use that word, but he essentially says Kennedy's martyrdom and enact this bill. He basically says, even if you don't like the bill, we have to do this because it's what's right and it's what Kennedy would have wanted. The other thing, he then carries that same urgency through up until the signing. And you can go listen as well on YouTube to the signing statement that he gives. And the whole, there's a continuity and between the very first speech and the very last speech, and every speech he gives in between, and every press statement he gives, and every answer to every press conference, and every little speech he gives to the Florida Democratic Committee. Everything has an urgency not only to pass civil rights, but to do it without compromise. And he said this in private, too. He said to Humphrey, and he said to Dirksen, and he said to Mike Mansfield, the majority leader, I will not accept a compromise. We must be here till the very end. He's actually doing the opposite of what we think Lyndon Johnson does. He is not negotiating. He is not wheeling and dealing. He is saying the time for that has passed. We have to have a bill, and we have to have this bill. And it's amazing. It's something that you don't think politicians do. And yet, for him, he felt that moral urgency. He felt the absolute need to get this through. And yes, of course, he stood to reap huge political benefits for it. But I really do think that he was speaking from a moral and ethical center that maybe people didn't appreciate, that a lot of people don't appreciate today, but that really came through in those speeches and I think was absolutely honest and was vital to the bill passing the way it did.
Well, that moral and ethical center is powerfully conveyed in this wonderful book. Please join me in thanking Clay Rosen.
Thank you. Thanks, Jeff.
Really great.